everybody. Welcome. I'm Kathy Phelps. Thank you for joining us today. This is the Federal Equity Receiverships, the third in our series of three, entitled Digging Deeper in Asset Recovery and Distribution. This is part of the Financial Poise Federal Equity Receivership series. And I want to thank Financial Poise for hosting us today. You can read more about them on slide 47. Don't worry about slide references today. If you're not looking at it, that's okay. They're not necessary for the presentation, but just in case you're interested, I may cite to some slides here and there. So we also want to thank our co-producers of this webinar. The first is the National Association of Federal Equity Receivers. The other is the Daily DAC. You can read more about them on slides 43, 45, and 46. And of course, the Financial Poise webinars are supported in part by sponsors. And we thank our sponsors. The sponsors for this are the MaxX Asset here on slide 4 that you can see, and also the National Law Review. So thank you to the sponsors. So now before we begin, our disclaimer, some of us are lawyers here. We just want to provide this to you, remind you that you are not our clients, we are not your lawyers. What we do here today is for general education purposes. It's not for you to act on without appropriate advice. So now moving on, let's meet our presenters today. So we have here Melanie Damian of Damian and Valori, LLP. We have Kelly Crawford of Sheep and Stone, and we have Gregory Hayes of Hayes Financial Consulting, LLC. So thank you again. My name is Kathy Phelps. I'm a partner at Raines Feldman Luttrell in Los Angeles. So you can see our names here on this slide. If you want to read more about our bios, they're on slides 39 through 42. We're not going to turn this into an infomercial about us. So moving on, we are going to talk, we're going to dive a little deeper on our first two webinars. We talked more generally about what receiverships are. Second webinar was really the order appointing the receiver, that's the governing document, and what all of the duties and the obligations are receivers. And today we're going to dive a little deeper really in the asset recovery and the distribution side and what we see there. Because there's a lot that receivers can do, a lot of value that can potentially be recovered for defrauded victims. So here are our three webinars. So on this one, just a little bit of an introduction. So receiverships, and I've mentioned this in the prior two episodes as well, they're of a lot of different varieties, right? They can be initiated in state court or in federal court. They can be a regulatory receivership where one of the regulators, either at the state court or the federal court level, is appointing a receiver. They could be a private action. The form of the order, which is generally what governs a receivership, can be a full equity order, which again, if you're interested in that, go back to our episode number 2. But that really allows for a receiver to have a broad range of duties and responsibilities and powers. One of those powers being the ability to marshal and collect assets, and then to fashion a distribution plan where once they brought in all of the money, then they can propose about how that's going to be distributed. So there are lots of different kinds of receiverships, things that we see sort of typically the types of cases that end up in a receivership often involve fraud. Whether that's a regulator that's initiating the receivership or maybe a group of defrauded victims. And so you see a lot of allegations about fraud. You often see in those cases that a lot of money has kind of gone sideways, wherever it may have gone. And so one of a receiver's obligations may be to look at, well, how can I bring that money back in? Who might I sue? And we're going to talk a little bit in depth today about a particular type of litigation claim that a receiver can bring, known as a fraudulent transfer claim. So let's start first, Greg, and let me start with you about what are the types of assets that receivers see that they might be interested in trying to collect?
Well, receivers diligently pursue all potential recoveries, and in a case, you never know what you're going to recover and what you're going to find in the case when you're appointed. But receivers go through the fraudulent enterprise and try to recover everything they can, which may include funds paid to investors, funds paid to sales agents is always a big category. Real property that could be purchased in the fraudster's name or in some other person's name. Usually you find some vehicles. Often you'll recover an airplane. often you'll have a yacht to recover, jewelry, gold bars as an example. We had a case where we recovered a lot of gold bars, livestock even. One case we recovered horses one time. So and then payments to creditors or vendors. So you never know what you're going to find in a case, and that's the beauty of being a receiver. You always in some new business and learning some new business. We've operated businesses and sold businesses that were owned by the receivership. So receivers recover a wide variety of assets from a wide range of types of defendants, and it all starts with a detailed forensic accounting of all the payments, and then the receiver and the counsel investigate what claims to pursue.
Kelly and Melanie, do you guys have any random stories of assets that you've collected or seen in a receivership case?
I think that's a really good list. I mean, I know I've sold a helicopter, a plane, a seat on the exchange board in Chicago. That was a unique asset that we sold. So, and as Greg said, racehorses, livestock, those are things you want to sell as soon as possible.
And sometimes there's interest in companies, investments made in other companies. Sometimes there's investments made in other frauds. So there'll be claims in other Ponzi schemes. I always find it surprising when the fraudsters are defrauded and that you have a claim in another Ponzi scheme. So that happens. I think one of the more unusual assets I had to recover was farmland in Venezuela, which couldn't be privately owned. And so the interest in the farm had to be sold in an unusual way, especially if you wanted to do it legally, which we had to do. Not all of the transactions follow what would be considered to be proper under US law. So
Okay,
receivers do have to follow the law.
So as you can hear, it could be anything that you find yourself with in a receivership case. So let's turn a little bit to litigation claims that you can bring. What are the types of litigation claims? Melanie, what's your experience with that?
Yeah, and so I think this is a really great topic because while it's great to have assets like listed by Greg and what we were talking about, cars and gold and bank money and bank accounts, best case scenario, you find some of those things, but sometimes there's nothing there that you get appointed and all of the assets have been dissipated and all you have are potential claims, litigation claims. So what are the claims that can be brought in a receivership is essentially any of the claims that the entity itself would have. And we're going to talk more about, what that means to stand in the shoes of the entity and bring those claims. And a number are listed here on the slide. And we're going to spend a lot of time talking about fraudulent transfers, which is money sent out not for value or at least reasonably equivalent value. And we'll talk more about what that means. But, this is transfers that went out not to benefit the receivership estate, but to benefit sometimes the individuals or are what we call net winnings. So investors who invest in Ponzi schemes and get, purported profits, which are not actual profits, but just money from other defrauded investors. Very common claims are aiding and abetting fraud and aiding and abetting breach of fiduciary duty. And I think we'll be talking more about those. There can also be negligence claims. Malpractice claims are brought quite often by receivers. And this is against lawyers or accountants who perhaps did not give the best advice to the defrauded investors or perhaps had some knowledge of the fraud themselves. And then some of the claims, depending on the nature of the regulatory receivership, there could be securities fraud claims. And I think we'll talk about those more in detail, but that's the biggest claims. There are sometimes contract claims. If you're standing in the shoes of the entity, the entity could have made loans and it needs to collect on loans, or it has agreements where the agreements have not been fulfilled because they may have been with people who have now decided they're not going to fulfill their obligations to repay or whatever it is. So sometimes there's these straight out breach of contract claims.
Okay, yeah, so, and this is frankly not the full list, right? There's, depending on the facts in your case, there may be other types of claims. But Melanie, can you just do an overview? Because I think I'm gonna ask Kelly to dive a little deeper on it, but what with this concept of fraudulent transfers, can you explain it a little bit?
Yeah, and so fraudulent transfers comes from the bankruptcy code, and there's a analogy that receivers use. It's most of them are proceeding under the state laws, which are Uniform Fraudulent Transfer Act. And actually, I think that claim has a misnomer, and the new uniform law is called Uniform Voidable Transfer Act. And I think that change in name, it will be helpful when bringing these claims, because it's not necessarily the fraud of the recipient of the transfer that matters. It's the fraud of the transferor. So the entity that is usually the receivership entity, or those people that were operating the, in most cases, a Ponzi scheme, or making their fraud and making the transfer. And so there are two types of fraudulent transfers, and I know Kelly will talk more about that. There's two sections of the statute. One is actual fraudulent transfers, and the other is constructive fraudulent transfers. And I would say I haven't ever had a federal equity receivership case where we haven't brought some fraudulent transfer claims, or voidable transfer claims, depending on which state you're in, because some states have now adopted the new Uniform Voidable Transfer Act, and other states have not. Florida has not yet adopted it, although we've been encouraging the legislature to adopt it.
Oh, I did not realize it hadn't adopted it. Interesting. Okay, so Kelly, let's do a little bit of a deeper dive on the actual fraudulent transfers, actual fraudulent intent, and we'll talk about the constructive later. So help us understand this.
Yeah, and so, the big question whenever you start a receivership is, where did all the money of the investors go? Because as Melanie said, there may be a situation where there's very few assets left. And so you do the forensic accounting that Greg talked about, and you look at the bank records, and you start looking at transfers. And the way that you're able to get transfers recovered and back into the receivership estate to give back to the defrauded investors is through filing these fraudulent or voidable transfer actions that Melanie talked about. And as she said, there's two types that we'll talk about today. The first one is actual fraud, which is again corresponds with bankruptcy code section 548A1A, as shown on the slide there. And so for an actual fraudulent conveyance claim, the focus is upon the receivership entity and their intent in making the transfer. And was the transfer made to a third party with fraudulent intent by the receivership entity for the purpose of hindering, delaying, or defrauding a creditor? So that's the test. And the clearest case would be there's a defendant who's being sued or being investigated, and they know that they're about to be sued or they've just been sued, and they want to protect all their assets from being recovered by the creditor who's suing them. So they transfer all their assets to a trust or to another entity that they still control through a friend or themselves, or hide the assets. I mean, that's the clearest case of a fraudulent transfer. And as the receiver, in order to prove that the receivership entity acted with fraudulent intent in making the transfer, you can look at things which are called badges of fraud. And so what you do is you look at, they're listed there on this slide. You can look to see, was a transfer made to an insider? This would be, like I mentioned, a family or a friend or an officer of the company, somebody who's going to basically act on behalf of the transferor and hold the money as a favor and give the money back later, something like that. Or did the debtor or the defendant, in this case, retain control of the property that's transferred? And this oftentimes happens with trusts. You'll find out that property has been transferred to a trust, and then you look at the terms of the trust and you find out that the receivership defendant still actually has control of the trust or the trustee. Was the transfer concealed? Was it being hidden from the creditors? Did it occur at a time when the debtor was being sued or threatened with suit? And did it basically leave the receivership defendant or the entity without any assets? Did it render it insolvent as a result of the transfer? Did the receivership entity, is he in hiding? Is she in hiding? Did she take with her assets and she's hiding those from the creditors? And then also, did the receivership entity receive any type of value, reasonably equivalent value in exchange for the transfer? And so when the courts try to determine whether or not actual fraud has been proven, they will look for evidence of these badges of fraud. And some courts say it only takes one badge of fraud. Other courts say, no, you need to have at least two or three. You don't have to have all of them. So a receiver can look at those to try to establish, improve the burden of proof that there was actual fraud with the transfer.
And how does this play out in a receivership case, one that involves fraud, obviously?
So if you have in receivership cases, most of the time you're dealing with a Ponzi scheme. And a Ponzi scheme is going to be basically when it was named after Charles Ponzi, who came over from Italy in the 1920s and had a postage stamp scheme where he raised a lot of money, but it was shut down by the authorities because he was basically using new money to pay a previous investor's false returns. And so that's basically the definition of a Ponzi scheme, is when you're relying upon new investor funds to pay fictitious returns to previous investors and to call those profits. And that's what would be fictitious profits. And I had a case in East Texas where an accountant, small town in East Texas, he was investing and doing well in his investments, and he was sort of bragging about his success in investments to his friends at church and socially. And so they came up to him and said, hey, can I give you my money for you to invest for me? And we can just split whatever profits 50-50. And so he said, sure. And so that's how this whole Ponzi scheme started, is people gave him money to invest. And so he invested it. And, because of his own pride, when he lost the money and they'd say, hey, how's my money doing? He'd say, oh, we're doing great. We're making great returns. And so they go, okay. And then they'd ask for their money to be paid to them. And so he wouldn't have it because he actually lost the money. So he would have to get other investors to pay back the first investor. Well, this scheme grew into like an $80 million Ponzi scheme. And it just started off small. And, he didn't really start off to become a fraudster, but because of his pride and not just being able to say, hey, I lost your money in this investment, he tried to cover it up and just dug himself into a big hole. So when a receiver is able to prove the existence of a Ponzi scheme, then most courts will hold that the transfers by the receivership defendant were made with fraudulent intent as a matter of law. And so you don't have to worry about proving the other badges of fraud. You just say, hey, this was a Ponzi scheme. Here's the finding. These are usually SEC cases or CFTC cases. And once you establish that it's a Ponzi scheme, the court says, okay, there's fraudulent intent as a matter of law. And so once you've done that, then you basically have to disprove the amount of money that the transferee received. And then the burden shifts to the transferee, whoever received the money. They now have the burden of proving that they received the transfer in good faith and that they provided reasonably equivalent value. So they have to provide both of those. So this would be, for example, investors, and they've invested in the Ponzi scheme. And most of the time they'll say, I had no idea it was a Ponzi scheme. I just thought it was a good investment. And so I was acting in good faith. And then you can say, well, but you didn't provide reasonably equivalent value because your money was never invested. Your money was just used to pay other investors these fictitious profits. So the receiver is able to claw back or recover the fictitious profits. Another example are commissions that are paid to salespeople, broker dealers, and they are the ones who solicit the investments. oftentimes they actually do know it's a Ponzi scheme and they're just covering it up. But even if they say they didn't, they're not providing value. The only value that they're providing is they're expanding the scope of the Ponzi scheme. They're just adding to the number of victims. So there's no value there. And then you have transfers to family and friends, and they're not providing any value in return. The easiest claim to prove, quite frankly, is to charitable organizations. And you'd be surprised how generous some of these receivership defendants are with other people's investment money. And so I've had to go to, great charities, churches, great charities, and say, hey, this person was running a Ponzi scheme and made this huge donation to you, but it was all made with investor funds. It wasn't legitimate money, and the investors gave their money to be put into investment. They didn't give it to go to the March of Dimes or whatever. And so it's a very straightforward case to prove, and reluctantly the charities will have to give the money back. And then fees also that are paid to professionals. There's a question about what they knew or should have known, and again, what value that they're actually providing.
Thanks, Kelly. That's a great overview. On the charitable contributions, in some respects, they're easy cases, but in other respects, I think they're some of the harder cases because those charities, from a interpersonal standpoint, I suppose. Well, number one, sometimes states have statutes that can be protective of those contributions, so you actually have to kind of pay attention to your jurisdiction. But it's also a little bit tough because those organizations don't have that money. Probably they've used it for whatever reason that they needed the money for their operations or overhead, and so they would actually sometimes have to go out and solicit new money from new contributions in order to pay back the Ponzi scheme. So to me, those are not easy cases. They may be easy in terms of proof because there's no value coming back, but difficult in terms of what the right thing is for the receiver to do. Those I think are a little bit fact dependent, but yeah, all those other areas are definitely places that receivers can look to try to bring money back in. All right, so Greg, Kelly told us a little bit about, well, if you prove a Ponzi scheme, that's going to make your proof of an actual fraudulent intent claim easier. How do you prove it's a Ponzi scheme?
Well, first I want to mention that that's an interesting story that Kelly was talking about, and I had a case that actually started the exact same way. And one gentleman, and he's the guy that the defendant that I brought to a NAFR conference one year and spoke to the conference about the scheme that he had done, the Ponzi scheme that he had run for years, and he was the only honest crook we've ever met. And he explained how it started and how he borrowed $100,000 from friends and family and only invested half of it with another crook. And lo and behold, he started paying returns and it grew to a $100 million fraud. But anyway, getting back to some of the common items we see in Ponzi scheme is that, it's returns that are paid to investors are primarily funded by new investor money rather than any legitimate business profit or any legitimate earnings. And it creates an illusion of a successful investment when in reality there's no underlying legitimate business or source of profit, and generally involved high returns and little or no risk, and often there's some sort of a guarantee there. So some of the common things that we see are the high returns with little or no risk, and a lot of them have some sort of side deal with a guarantee from some other fund or a trust. We see a lot. Always paying prior investors with new money to attract new investors. Generally, they're insolvent from the beginning. There's generally no business operation. Commingling of investor funds with other entities. Generally, there's several different entities that are all related and sort of common names. Use of funds for non-investment purchases. We talked about, buying yachts and planes and other assets for the, and they're living, the fraudsters living high on the hog and living a lifestyle that they can't afford. Consistent returns is one issue that, investments tend to fluctuate, and a lot of these schemes pay a fixed return even when the market's going up and down, even though they're supposed to be investing in the market, like the Madoff case. Unregistered investments, most of them aren't registered with any investment body. Often we see that some sort of very secretive or complex type strategy that nobody understands. They sort of fraudster explains that it's too difficult to explain and you wouldn't understand it, but they've got some secret method to beat the market. I've found over the years that a lot of times that fraudsters apply on the newest technology and something that investors don't really understand yet, but they see in the news every day. Like, for example, might be artificial intelligence now, that there's some, if they pick up on some new item and promote that. And a lack of transparency, scammers be very vague and invasive about the source of the investment returns. Um, Generally, you'll see, very difficult to get your money back and have trouble with withdrawals. Um, and so, lack of any audited financial statements. You never have any kind of audited statements in these schemes, and a lot of unlicensed sellers. So those are a few of the types of elements we see in Ponzi schemes, and some of the issues we use to prove that a Ponzi scheme existed. And to
Okay.
demonstrate that the Ponzi, and we do like expert reports that we file with the court to show that it was a Ponzi scheme. We go through all those elements and explain it. And I like to have a chart that I use that shows the monthly cash that's brought into the estate, and then layer in the promised returns to show that the enterprise was always insolvent. And then I'll also put a line on the chart that shows the actual cash balance and then the liabilities for what's been promised to investors. And so we go through detailed reports to explain all the deposits and what's been promised to investors to prove the Ponzi scheme. And it's the term Ponzi is become more prevalent over the last decade since Madoff. Back in the old days, we used to joke nobody knew what a Ponzi scheme was, and Madoff made it more famous. But by everybody knows what it is now. But you'll see the term used a lot in variations of the term to make a fraud sound more sophisticated. You'll see the media a lot calling a scheme a Ponzi scheme when it's really just a pure fraud. And a lot of pleadings, you'll see terms like Ponzi-like or Ponzi type or Ponzi in nature. There's a lot of different sort of characteristics when you can't prove that it's an actual Ponzi scheme under the classic definition. But there's sort of been a tendency to broaden the definition, and there's no court that says there's absolute list of required elements, and a lot of these different factors are just various issues that are considered in claiming that it is a Ponzi scheme. So courts typically look for a general pattern of activity than rather than any specific requirement. One case that I'll mention is the SEC versus Management Solutions in the United States District Court for Division of Utah, and they did extensive review of the terms and conflicting definitions of Ponzi schemes across many courts.
Thank you, Greg. And of course, people have different reasons for wanting to label something as a Ponzi scheme. One is, to sort of the sensationalism of it, and it, draws people in and it's interesting. But from a legal standpoint, one of the reasons is, Kelly mentioned earlier, it's this concept called the Ponzi scheme presumption, which can be a great aid to plaintiffs bringing fraudulent transfer claims to try to establish that there's a Ponzi scheme in order to establish that fraudulent intent. And Greg, you want to just explain a little bit more about what the Ponzi scheme presumption is?
The Ponzi scheme presumption, it's a legal principle that in a fraudulent transfer action, it allows the court to infer that all payments made in furtherance of the Ponzi scheme were intentionally fraudulent, and it shifts the burden of the payment, meaning the recipient of the payment must demonstrate they acted in good faith and received reasonably equivalent value to avoid having the payment clawed back. And the basis for the presumption is that the mastermind that's responsible for operating a Ponzi scheme knows that a scheme will fall apart as soon as the new investors, the pool of new investors inevitably runs dry. So when the money runs out, the scheme's over. The presumption makes alleging actual fraud easier, as the receiver just has to prove the Ponzi once and not in every case that the receiver is going to bring. The presumption allows the court to presume that the debtor's payments were made with the intent to hinder, delay, or defraud other creditors without requiring specific proof in every individual case. And once the scheme is established, once you've proven that you have a Ponzi scheme, the court can presume that the debtor's fraudulent intent regarding payments made during the scheme, this shifts the burden of the proof to the recipient of the payment to demonstrate they acted in good faith and received reasonably equivalent value. So they're basically, in some cases, have said that there's 4 elements you have to prove that we've discussed. Some of the types of elements, but some of the elements to prove the presumption was the deposits were made by investors. There were no legitimate business operations. The purported business produced little or no profits. The source of the payments to investors was cash infused by new investors. And the presumption is that all transfers in the scheme were paid for the purpose to hinder, delay, or defraud creditors.
So, it's interesting when you start thinking about the Ponzi scheme presumption. And so let's say you've hired somebody like Greg, you've established that it's a Ponzi scheme. Is every transfer that was made a part in furtherance of that Ponzi scheme? And I've seen cases discussing, well, if you're paying employees salary and they were doing some legitimate work, was that in furtherance of the Ponzi scheme? Or the utility bills to keep the lights on, or the landlord, is every single payment a payment in furtherance of the Ponzi scheme? So in addition to establishing that it was a Ponzi scheme, in order to get that presumption, there's sort of that extra layer of, well, was the particular transfer that you are seeking to avoid in furtherance of that Ponzi scheme? And so there's some really interesting issues there. Sometimes maybe it ends up being more work than a more traditional badges of fraud analysis, which we'll talk to Melanie about in a minute. But Greg, can you use the Ponzi scheme presumption in a case that's not fully a Ponzi scheme?
Generally, no, and the presumption applies to Ponzi schemes, even in the case it does not fall within the classic definition of a scheme. And so the burden is on the plaintiff, the receiver, to convince the court to apply the presumptions. This was addressed in a case here in Atlanta in the International Management Associates case. It's a 2017 case holding that only transfers made in furtherance of a Ponzi scheme are subject to the presumption. So that language it seems to make a lot of sense and in furtherance of the scheme. So some of your trade creditors or employees would not be included in that definition. But many recent cases stretch the classic definition of a Ponzi scheme. And we've talked about how some are called Ponzi-like or Ponzi in nature. And, some of those cases, regulators have tried to infer the Ponzi presumption, but not all courts recognize the presumption. And it's important to have the facts right and expert testimony on the true nature of the Ponzi scheme to establish the Ponzi presumption.
Okay, so Melanie, sometimes maybe you can't prove it's a Ponzi scheme, or maybe you don't want to prove it's a Ponzi scheme, but you can still establish actual fraudulent intent. Yes? How do you go about doing that?
Yeah, and so I think, well, that was great that Greg was talking about all that. And I don't know that we may have skipped over, and if there are people who are sort of new to the practice area are wondering, like, how does this happen in practicality? What was great about Greg providing that is he would be the witness, right? So that's how you do it. Generally speaking, you have a forensic accountant come in like Greg and rebuild the financials of this scheme enterprise and tell you, like, where did the money come from? Is this investor money? Was it commingled? Where was it sent? Were they spending more than they were coming in? Was there any legitimate business enterprise to begin with? Is it a Ponzi scheme if there's a legitimate business enterprise? I was actually asked that in a trial, like, but there was a real business here somewhere, like a little piece of it was a real business. And does that mean that the Ponzi scheme presumption cannot apply? And so The answer is no, it still can be a Ponzi scheme, even if there's a legitimate business enterprise underneath it. If the main business of the business is to take investor monies and pay investor money out more than you're bringing in. But how you prove it is with someone like Greg, who comes in and testifies. And so when you don't have the Ponzi scheme presumption, either because it hasn't been proven yet. And I think what Greg alluded to with regard to once it's proven. So oftentimes in at least the regulatory receiverships, there'll be some judgments already entered. And so there'll be law of the case where the defendants, the entity and or the individual defendants will have agreed that they had been essentially operating a Ponzi scheme, that the allegations were correct or have already been found to be a Ponzi scheme. So there's some findings from the district court. And so once you have that, will the courts in the fraudulent transfer cases consider that already as a Ponzi presumption, or make you go through it? We've had to go through the exercise even where there were findings in the main receivership case that it was a Ponzi scheme. And so if you don't have the presumption, but you have the Ponzi-like, you're going to also have the badges of fraud. Oftentimes, even if you don't have the Ponzi presumption, you have these other badges of fraud. And I know Kelly already kind of went through all of them, but the transfers to the insiders are big ones. What you wind up seeing is things like they quick claim their house to their mom right before the Ponzi scheme was filed. I see Kelly smiling because we have that happen in one of our cases, right, that we're dealing with right now. Or they transfer, whatever the legitimate business interest is to an entity that's owned by their wife. And so you have to go underneath with a forensic accountant like Greg to testify, here's when this happened, here's how it happened, here's why they're insiders, here's why they still have control of the entity. So when they're pretending to transfer some asset, they actually maintain control because they're owners of the entity to which they transferred it. And so I don't think we need to go through the other badges of fraud. Again, they're on the page, and Kelly did a great job of going through them. So I thought it was more important to talk about sort of how you go about proving this. Insolvency is going to be a big part of any trial on issues of badges of fraud or fraudulent transfer.
Okay, thank you. Let's turn now to constructive fraudulent transfer claims. Kelly, why don't you give us a little bit of a description on those?
Sure. So one of the disadvantages to a receivership versus bankruptcy that we talked about, I think the last session we had, is that we don't have this 90-day preference period to set aside transfers that were made within 90 days of a bankruptcy filing. So we don't have that. So we have to rely upon these fraudulent transfer causes of actions and claims. And so under the Uniform Fraudulent Transfer Act or Avoidable Transfer Act, there's really two types: the actual fraud claim, and then the cousin to that is the constructive fraud claim. And so under the actual fraud claim, you're focusing on the transfer or the receivership entity or receivership defendant, and you have to prove that they made the transfer with fraud to hinder or delay or hurt a creditor. Under the constructive fraud statute, you don't have to worry about proving fraudulent intent by the transferor, but what you ask is, did the debtor or the receivership defendant or entity in this case receive less than reasonably equivalent value for the transfer, and did the transfer leave the receivership defendant insolvent? And so that's the focus of the inquiry. And in a receivership case, where you have a Ponzi scheme or you have misrepresentations, then each of the investors have a claim to get their money back, essentially. So a receivership entity who has received the money under false pretenses has a liability owing to each of those investors to make full restitution to those investors. So any transfer that doesn't receive reasonably equivalent value in exchange is going to essentially leave the entity or the defendant insolvent, because they're not going to be able to repay all of the investors. And so that's what you focus on. And so as a receiver, it's interesting. Usually what we'll do is when we're trying to set aside a transfer, we'll assert both claims. We'll assert a claim under actual fraud, and then we'll also assert a claim for constructive fraud, and try to get that way we have both statutes. The constructive fraud statute of limitations is 4 years after the transfer. The actual fraud statute of limitations is 4 years after the transfer, or 1 year after the discovery. So when you're a receiver, courts will look at how long did it take you to discover when this fraudulent transfer occurred, and they'll give you 1 year in which to bring the cause of action after that time. So usually we bring both causes of action.
Okay, thank you. Yes, and that is we do see that most frequently. You want to dive a little deeper into what reasonably equivalent value is?
Sure, and it's really become a big issue in the courts, and the courts have a different view upon how you determine reasonably equivalent value. There's these two approaches: the subjective approach and then the objective approach. So under the subjective approach, the Fifth Circuit had a case that I actually argued called Warfield versus Byron, that involved Washington law under the Uniform Fraudulent Transfer Act. But the broker in that case, it was a Ponzi scheme case that the SEC brought. So we had all the Ponzi presumption and everything. But the broker said, "Hey, I just received the market rate of any other seller of these type of products. I received market rate commission, and I had no knowledge that this was a Ponzi scheme. So I had good faith, and I provided reasonably equivalent value." And so, I argued that they provided no value, because if you look to the entity that they provided services to, all they did was enlarge the scope of the scheme and increase the amount of restitution that was the entity was responsible for making. And so the Fifth Circuit issued their opinion, and they agreed. And so it was a good opinion for us, because that's what it held, is that you focus upon what benefit was there to the receivership entity as a result of the services that were rendered. And that's how you measure the benefit. And then along came, there was a big receivership called the Stanford receivership. This came out after Madoff, but it was a big receivership here in Texas. And the receiver in that case was Mr. Janvey, and he filed suit against the Golf Channel to recover all the monies that Stanford had paid. They had paid millions of dollars in advertising to advertise their Ponzi scheme investment program on the Golf Channel. And so Mr. Janvey, as receiver, filed a lawsuit against the Golf Channel to recover those monies as a fraudulent transfer. And it's really interesting, because the Fifth Circuit issued about 3 different opinions, and they completely changed course on their decision about how you should measure reasonably equivalent value. At first, they said, we rule in favor of Mr. Janvey, and there was no benefit because this was a Ponzi scheme, and all they did is enlarge the number of investors. And then later on, they changed that opinion, and they said, you know what, we need to have the Texas Supreme Court decide this issue. So they certified the question to the Texas Supreme Court. And the Texas Supreme Court said, well, we're going to use a market value approach, and you try to determine not in hindsight, oh, we found out that this was a Ponzi scheme, but at the time, was there market value exchanged? And so they said there was. They said the Golf Channel had other customers who would have paid the same rate for those commercials. And so the Golf Channel ended up winning that case. And then we have this case, another circuit in the 11th Circuit, the McHenry versus Dilworth case, where the landlord had rented out this house to a corporation that went into bankruptcy. And so the trustee filed an avoidance claim against the entity to recover the rent that had been paid, because the corporation had no benefit. Only the principals of the corporation were using this house. The corporation wasn't. So the corporation received no benefit. as a result of the monies that they were transferring to the landlord. But then on the 11th Circuit said, no, we're going to look at this objective approach and say, was their market value exchanged? And they said the amount of rent that was paid for this type of property was market value at the time. And so they ruled in favor of the landlord. So it's going to depend upon the jurisdiction that this case that the case is argued. And it's one of those things where the law is just constantly changing.
Thank you for that. And the value component is an issue on a constructive fraudulent transfer claim. It can also be in terms of the defense. When a defendant gets sued and they're like, well, hey, I have a defense. Melanie, tell us about the good faith value defense.
Yeah, so that, I mean, this is where all the action happens in in the fraudulent transfer cases. It's both an element of proof in the constructive fraud transfer cases and an affirmative defense in the actual fraud cases. So even if you have the Ponzi presumption, a transferee can claim, well, I have the defense because I received it in both good faith and gave reasonable equivalent value. And is really a big important part of this fight because you have to show both. And so the fights that happen over good faith are generally about what they knew or should have known about the fraud at the time. We had an entire trial about good faith with the brother of a Ponzi schemer who was the, very high paid commission salesperson of the fraud. And he claimed that he didn't know that, it was a fraud. His brother kept the books out of his view. And we were able to show that he was not acting in good faith because he had reason to know, because information was becoming available to him over time through emails, that he did not have good faith. So that is, they have to show both good faith and reasonable equivalent value. He was claiming, well, I gave reasonable equivalent value because commission salespeople make this is an average pay of a commission salesperson. I was a commission salesperson before I became a commission salesperson for this. And so, Kelly gave some really good scenarios where value is fought over. And so we do have, a lot of litigation about value. And it the case law is clear that it has to be value to the debtor. And so I'm going to disagree with some of the cases because there's cases that I think Kelly is right that there's cases sort of all over the place on that. But, for example, can you sue as a receivership entity for return of tuition that was paid for children of the fraudster by the receivership entity? I would say yes, we have done it, we have recovered it. So even though that tuition was market rate, what other kids would pay to go to that school at that time, it was not a reasonable equivalent value to the receivership entity, which was being funded by investor funds. And so these are the types of cases, and I see Kathy smiling because these are the hard ones, right? When it's like you have to sue a church who received $1 million donation so that the Ponzi schemer could seem wealthy and benevolent and recruit investors from the church, right? And so it's part of the fraud, and you feel bad going after charitable enterprises, schools, but it's not their money. It wasn't their money to give away, and it's our job to pursue the recovery of it on behalf of all of the victims of the fraud. And so these are the fights that we have, and this is where those battles over in the fraudulent transfer, avoidable transfer act cases happen over good faith and fair value. And a recent issue that came up that's listed here on the slide, if you put good faith make good faith an issue that you were acting in good faith, had no reason to know, are you waiving your attorney-client privilege, or are your communications becoming at issue in the case? The Middle District of Florida said yes. Those cases also go in different directions depending on when and how you sought advice of counsel. So there's a lot of interesting issues that come up in these fraudulent transfer cases, but it is in almost every receivership, these are the claims you're bringing, and these are the fights that you're having. And so really staying on top of this area of the law is a good receivership tip for those people interested in working in this area.
Well, and another place where it's a little challenged is when you're looking to the investors who are defrauded victims, trying to get money back from them. And just real quickly, so we can get to aiding and abetting, Kelly, you want to just explain the difference between a net winner and a net loser?
Sure. So one of the things that we'll do is we'll look and see, okay, who received their principal investment back plus a profit. And we'll go to those people who received a profit and say, look, the profit you received came from somebody else's principal investment because there was no legitimate investment. And so you need to give that money back. And it's a fraudulent transfer claim. And they'll say, well, I had no idea. I was acting in good faith. And then we again have to do, as Melanie said, we have to say, well, you have to prove both. It's you acted in good faith and provided reasonably equivalent value. And your money, even though you thought it was being invested, you thought it was generating returns, it was not. And it was, so therefore you need to return the fictitious profits. And then we'll use the money that has been recovered in the receivership to try to pay back whatever principal losses we have from the investors. And so when we have a claims process, we oftentimes have investors who file claims with us, and they want to receive not only the principal amount of their investment, but also the profits that they were promised. And we always have to say, no, you're limited just to the principal amount of money that you invested, because that was the only real dollars, or that was only real value that was provided.
Okay, great, thank you. We're running out of time, so I'm actually going to skip over another defense that may or may not be applicable to receivers in the Bankruptcy Code Section 546E. Let's just briefly hit what an aiding and abetting claim is. And Kelly, you want to talk about that a little bit, and then we'll turn to quickly what the defense is to that.
Sure. So, the big question is, how does a person who's operating an illegal Ponzi scheme get investors to invest? And so you then look at the gatekeepers, and the gatekeepers are those institutions. These are well-known accounting firms or law firms or trading platforms who end up getting tied somehow, some way to the Ponzi scheme operator. And so what happens is the Ponzi scheme operator will hire, let's say they hire a big name accounting firm, and maybe they hire them to do just a little project for them. But then they're able to say to their investors, we've got this great investment program. My accounting firm is one of the top accounting firms in the country. My law firm is one of the top law firms in the country. We have an account at this bank, well-known bank. We trade on this platform. And so an investor goes, wow, well, this must be legitimate, because all these well-known entities who have all these checks and balances in place are in business with this person. And so that's how come they invest. And so as receiver, you step into the shoes of the entity, and you can bring these aiding and abetting claims, and you can bring these claims if they provide a material aid to the fraudster that enable them to receive the investment money in. And they did so either knowing about the fraud or with complete reckless disregard for the fraud. And that's where everything usually falls, is proving reckless disregard. It's rare that you're gonna have evidence that they actually knew it was a Ponzi scheme. But what you focus upon is all the checks and balances that should have been in place by a bank or an accounting firm or a trading platform, that for some reason they just completely blew through. That they just, for whatever reason, they made an exception, and they said, okay, well, this one doesn't matter. We're going to go ahead and let you be one of our clients. And so that opens the door then to these aiding and abetting claims. And there's always a standing issue with these claims as to which claims can be brought by the receiver, and then which claims actually belong to the victims. And so sometimes what I've done in cases is, if it's a small enough case, I've had the investors assign their individual claims to me as receivers so that when I bring an aiding and abetting claim, I've completely covered the bases. Their standing is no longer an issue. I'm acting on behalf of the entity. I'm also acting on behalf of the investors. So it's a good mechanism to bring in money from third parties, and the big hammer that you have against these people who provided aid and were abetting in the scheme is that they could be responsible for the entire amount of the loss to the investors, and that's usually a very big number.
Right. Now, so these defendants are often very aggressive about asserting defenses, not only to aiding and abetting claims, but other third-party tort claims. Melanie, you want to explain imperi delicto a little bit?
I do. I mean, I think Kelly's right. Causation, standing, those are broad. Impari delicto is often cited, but rarely can prevail with receivership cases. It's different for bankruptcy. Bankruptcy courts do permit the defense to be brought against bankruptcy trustees, but in most jurisdictions, impari delicto is not brought against a receiver. And the essential concept is, and it's on the screen, is where, you know, where both people are doing wrong, the defendant's position is stronger. And so we listed a case there, Scholes versus Lehman, which is a Seventh Circuit case, which essentially is a leading case that it can't be asserted against receivers, with the idea that in a receivership case, the wrongdoers are removed, and now the receivership entity is being operated for the benefit of the victims, and so the bad actor has been removed. There is some interesting litigation on the 11th Circuit that's happened, that if the sole control actor was the bad person, it's a standing issue rather than a impari delicto issue. But the 11th Circuit has found that when the sole bad actor controlled the entity, you can't bring the receiver can't bring aiding and abetting claims, because they stand in the shoes of the bad actor. If there was any innocent shareholders or innocent control people, that's removed. And so Kelly gave a great practice pointer in that case. Really, the best claims are brought, but then by the investors directly. So those claims can be brought by the receiver as a assignee or by class counsel for the benefit of the receivership estate. So that's happening in the 11th Circuit, and it's creating some issues.
Okay, there's a lot of activity on these issues across the country. All right, Greg, we've left you only a few minutes to talk briefly about distribution plans. So receivers have gathered up all this money, then what do they do with it?
Well, yeah, we've got a couple of minutes to talk about things that we spend hours talking about in panels, and we've done a lot of panels for NAFER on just distribution plans. But each case is different. We've had very simple distribution plans where we have thousands of investors and small amounts, to where we have very complex distribution plans and it all depends on a lot of different factors. And some of the issues are, the number of investors, the size of the investment, the accuracy of the information that you have. Is it worth the trouble and the time to go in and try to figure out and make certain everything's correct? The estimated cost of what it's going to cost to get to go in and correct, get the accurate information. Looking at entities that are commingled and whether you try to split those out and split up the investors in different groups. Withdrawals, a lot of times people take their money out and then they're out for a month or two and then they put it back in. How do you treat those people? Sales commissions, you might not have pursued the sales commission. So, and in some of the smaller cases, so you want to deduct those out in some cases. Looking at all the prior distributions that were paid. So you can tailor a distribution method that fits your case, and there's several different actual scenarios. One was the one we used for many years with the net investment was actual dollars invested, less the withdrawal. So that's the simple way. Rising tide is sort of a newer approach and something that we started using about 10-15 years ago, and that takes into account, it's a more equitable type of a distribution plan. So where you're treating both pre and post withdrawals the same, so you get to a more even distribution. What that does, and it's hard to explain in a minute, but it evens it out for the later investors. instead of everybody getting, say, 20%, then, or 30%, then they might get a higher distribution because somebody else was paid earlier in the case. There are some great materials on the NAFR website that talk about that receivers have done and explain the different methods and which method the receiver has chosen to use in this particular case. So it's going to depend on the facts in your case and what you convince the judge is the fairest distribution method.
Wow, Greg, that was a great way to summarize 3 hours of content in 3 minutes. I want to thank all three of you for joining us today as panelists. Thank you everyone for watching, and this will conclude episode 3. Thank you very much.